of Oregon for the County of Clatsop, Carol A. Epling, plaintiff versus State of Oregon, City of Astoria, Clatsop County, Astoria School District, 1C Craig P. Hops, and State Farm Mutual Automobile Insurance Company, a property and casualty insurance company, defendants. Complaint, 24 CV 08701, case number, complaint, personal injuries, auto pedestrian, uninsured, underinsured motorist benefits, claim for recovery of money damages in an amount exceeding 1 million and less than 10 million, ORS 21.1601C, not subject to mandatory arbitration, request for jury trial. Plaintiff alleges first claim for relief, personal injury negligence. Plaintiff Carol A. Epling is a citizen and resident of Astoria, Clatsop County, Oregon. At all times mentioned, West Marine Drive in the vicinity of where Ms. Epling was injured was and now is a public street and thoroughfare of the city of Astoria, Clatsop County, state of Oregon, extending in a generally north-south direction and was and is provided for the use of motor vehicle traffic. At all times mentioned, Denver Street was and now is a public street and thoroughfare in the city of Astoria, Clatsop County, state of Oregon, extending in a generally east-west direction and was and is provided for the use of motor vehicle traffic. At all times mentioned, Denver Street intersected with West Marine Drive. At all times mentioned, at the intersection of West Marine Drive and Denver Street, there was a marked crosswalk for pedestrians crossing in a north-south direction across Denver Street. There was also a stop sign at the intersection just east of that crosswalk regulating westbound traffic on Denver Street. There was another nearby marked crosswalk east of the intersection, the marked crosswalk at the intersection, and the stop sign at the intersection. At all times mentioned, defendants, State of Oregon, City of Astoria, and Clatsop County were public entities which owned, operated, and maintained West Marine Drive and Denver Street at and near their intersection, including the marked crosswalk at the intersection and the marked crosswalk east of it, as well as the stop sign regulating westbound traffic on Denver Street at its intersection with West Marine Drive. At all times mentioned, defendant Craig P. Hops was employed as the superintendent of Astoria School District 1C and at all times mentioned was acting within the scope of that employment. On or about February 22, 2022, defendant Hops was driving an automobile in a westerly direction on Denver Street in Astoria, Clatsop County, Oregon, intending to turn onto West Marine Drive. At the same time, plaintiff Carol Epling was crossing Denver Street in a southerly direction in a marked crosswalk at its intersection with West Marine Drive when she was struck by the vehicle being driven by Mr. Hops as a result of the negligence of defendants State of Oregon, City of Astoria, Clatsop County, Astoria School District 1C, and Mr. Hops, and each of them, as specified below, causing personal injuries to Ms. Epling as described below. Defendants State of Oregon, City of Astoria, and Clatsop County were negligent in one or more of the following particulars: in failing to adequately maintain the street markings for the marked crosswalk at the intersection of West Marine Drive and Denver Street, in providing two crosswalks across the same street in close proximity, in presenting a confusing and unclear point of crossing of Denver Street for drivers and pedestrians in the vicinity of the intersection of West Marine Drive and Denver Street, and in failing to provide adequate signage in the vicinity of the intersection of West Marine Drive and Denver Street. Defendants Astoria School District 1C and Craig P. Hops were negligent in one or more of the following particulars: in failing to obey a traffic control device in violation of ORS 811.265, and failing to stop as required by a stop sign before entering a marked crosswalk in violation of ORS 811.260.15, in failing to stop and remain stopped for a pedestrian crossing the roadway in a crosswalk in violation of ORS 811.028.1a and 4, in violating the right-of-way of Ms. Epling, in making an unlawful turn which could not be made with reasonable safety in violation of ORS 811.335, in failing to keep a proper lookout, in operating the vehicle at a greater rate of speed than was reasonable under the circumstances then and there existing, and in failing to maintain proper control of the vehicle. As a result of the negligence of defendants State of Oregon, City of Astoria, Clatsop County, Astoria School District 1C, and Craig P. Hops, and each of them, Carol Epling, was caused pain and suffering, polytrauma, fractured right clavicle, tearing, twisting, wrenching, contusing, and breaking of the muscles, tendons, ligaments, cartilage, bones, nerves, and soft tissue of the legs, ankles, and feet, multiple fractures of the left and right lower extremities, including left open tibial and fibula fractures and right bimalleolar talus calcaneus sustentaculum tali and fifth metatarsal fractures, all of which injuries and the consequences of them have required Miss Epling to undergo medical treatment, including surgery involving closed reduction, percutaneous fixation, right calcaneal fracture, debridement of right open tibia fracture, closed treatment of right talus fracture, lateral malleolus fracture, medial malleolus fracture, right fifth metatarsal fracture, closed treatment right clavicle fracture, another surgical procedure involving open reduction, internal fixation of left pillion, tibia only, and adjustment of spanning ankle external fixator in treatment of left pilon fracture, tibia and fibula, and another surgical procedure involving open reduction, left pilon fracture, fibula only, closed conservative management of right tibia fracture, closed conservative management of right talar body fracture, removal of external fixator and application of incisional prevena wound VAC times 2 in treatment of left pilon fracture, tibia and fibula, right talar body fracture, and right tibial intra-articular fracture, all of which injuries and the consequences of them are permanent and will or may cause her to require further medical treatment and have caused Miss Epling damages for non-economic losses in the amount of $7,500,000. As a result of her injuries, Miss Epling has sustained damages for economic losses for past medical and related goods and services in the approximate amount of $400,000 and will or may sustain damages for economic losses for future medical and related goods and services in an amount to be determined at trial according to proof. Plaintiff has complied with the provisions of ORS 31.275 by giving notice to the State of Oregon, City of Astoria, Clatsop County, and Astoria School District 1C as their specified second claim for relief, personal injury, underinsured motorist benefits. Plaintiff alleges the allegations contained paragraphs 1 through 11 above as through here fully set forth. At all times mentioned, defendant State Farm Mutual Automobile Insurance Company was and now is a property and casualty insurance company registered in the state of Oregon and doing regular and sustained business throughout the state of Oregon as a property and casualty insurance company. At all times mentioned, State Farm Mutual Automobile Insurance Company issued a policy of motor vehicle insurance covering plaintiff Carol Epling, including coverage for uninsured, underinsured motorist benefits. Defendant State Farm Automobile Insurance Company owes plaintiff benefits under the uninsured, underinsured provisions of the above-mentioned policy. Plaintiff has fully complied with the terms of the State Farm Mutual Automobile Insurance Company policy, or those terms have been waived. Wherefore, plaintiff Carol Epling prays for judgment against defendants and each of them for damages for non-economic losses in the amount of $7,500,000 for damages for past medical bills and the approximate amount of $400,000 for future medical bills to be determined at trial according to proof and for her costs. February 16th, 2024, Tishner D'Zuba Law Office, Daniel D'Zuba, plaintiff requests a trial by jury. Woo! Exhibit 1, Certificate of Service, 5th day of June 2024. I serve the foregoing defendant, City of Astoria's Rule 21. Okay, so thank you for listening.